And we're live with a lot of gratitude to John Hawkinson. It is Tuesday, July 1st, the year of our Lord 2025. It is 8:01 a.m. and after being a minute early because I was, you know, accidentally hit the go live button before 8 o'clock, it is now a minute late because I muted myself and didn't unmute myself until the very estimable John Hawkinson broke in and informed me so. As well, he should have, because that was the right thing to do. It is the 1st of July, the year of our Lord 2025, 8:01 a.m., and I have an announcement about July 1st, which is that, much to my surprise, the United Nations General Assembly fell down on the job and did not designate July 1st anything. In fact, it didn't do either for July 2nd, 3rd, or 4th. You have to wait until July 5th, the International Day of Cooperatives, before the United Nations General Assembly, which doesn't have a lot to do other than stopping wars, condemning Israel, and designating days, picked up the baton and made it happen again. So we're just going to observe a moment of blankness for the United Nations here. Here it is. Okay, yeah, there it was. That's where the normal day I would tell you what International Day it was. We're not going to do a blank part where I say something witty about, the day and how it fits into the calendar. Otherwise, we're not going to do that. I'm not going to tell you leave blank. But that's going to be the symbolic. We're going to do that until the 5th. Look, folks, I have been promised rain every day to cool things off by the powers that be, and the powers that be have not delivered rain. So the sun is shining, the birds are chirping, it's going to be really hot again, and I hope today is the day that we're going to get some rain. We're also supposed to have a guest this morning, but let's see if he shows up. Otherwise, I will just yammer at you for an hour. Um, uh, um, so, um, all right, let's talk about ChatGPT and humor. So, yesterday, I decided I was going to write a funny column about universal injunctions and the CASA litigation and the Supreme Court because I noticed that in the opinion of the court, there was not one good joke. Not one. Usually you can count on Justice Kagan to get in, a Marvel Comics reference. You can count on, um, uh, somebody slips in a good line. There is not a good line in the thing. Amy Coney Barrett, smart lady, not funny. Um, and all the majority opinions got no good lines in it. Um, there is Ben Wizner himself,
Hey,
Wisner,
Wisner, yeah, yeah. That's okay. We've
yeah,
only known each other for
for 20 years, and we're also the only people of our acquaintance who, at least you're the only person of my acquaintance other than myself whose name is Ben and then W
so
I.
I'll call you Ben Whitus.
Well, see, that's the problem. It's like people
Yeah,
call me Benjamin Whites all the time, and
yeah,
it irritates me, and so
yeah.
I'm habituated to pronouncing the W-I um, as as wi.
And I'm
And
habituated to not being irritated. So there we go.
well, I'm always
Yeah.
irritated, but Ben,
What's the
it is
situation, Ben?
it is wonderful to see your face. I was just complaining about the fact that I was trying to come up with jokes about universal injunctions um, and the CASA litigation because the opinions were completely devoid of humor. There was not a good line in either the majority or the dissents. There was some apocalyptic rhetoric.
Yeah.
There was some, but it was all, and then the
Our
commentary
our
has not.
communications department has said you are charged with talking about this case without using the word injunction. So that's a good challenge. Right.
Really?
So, well, I mean, we're not only speaking to an elite audience, we're trying to explain this case to the country at large. And the word injunction is a hang up. So
Did they tell you you're not allowed to make jokes about it?
that's never stated clearly. Um, I think it's generally implied and ignored by those of us who are old timers.
Right, I see. So I thought it was on me to write a column. I already wrote an earnest column about it. I already, but like to lighten the mood. And so I spent yesterday thinking about jokes I can tell about universal and maybe without saying universal injunction.
Did you get
Um,
there?
no, and
Do you
I tr
remember the old schoolhouse rock? Conjunction, junction, what's your function?
ooh, conjunction injunction. That's
So you could
good.
write lyrics, injunction, junction,
Yeah,
what's your function? Actually, even the question is the question that's at the heart of that case, right?
right. That's good.
It, it's
Maybe,
it's a it's a prompt for a joke, not a joke in and of itself.
right. So that's the problem I had. So then I went to ChatGPT and I was like, tell me jokes about universal injunctions. And they're all terrible.
Well,
And
that's good news.
most of them
Best
are.
news I've heard today.
But here's the funniest,
AI still not funny.
the only thing that was funny about it was its response to the question, which said, "Oh yes, looking at the humorous intersection between, you know, blah blah blah, the Supreme Courts and it's a narrow slice Venn diagram to be sure, but that's what makes it fun." And I thought, like, okay, that's pretty witty, but then the actual jokes all sucked. So last night, I meticulously put together the setup for a joke. And I have to say, it's a good setup. And then I couldn't think of a
Couldn't stick
punchline.
the landing.
I could not stick the landing, so I have held the column and I'm, um, uh,
All
going
right.
to work on it more today.
Godspeed, Ben.
Yeah. Ben Wizner, uh, let me introduce you. Ben is my old sparring partner on all kinds of national security legal issues. We used to have a frenemy ship, um, and
You
he is
think you think fellow travelership has washed away old frenemy ships long since?
so like I really can't stand the fact that all of my old frenemies are now like I can't find anything to disagree with them about.
We can
Uh,
disagree about the past and how much the past is responsible for the present.
Oh, let's talk about that. Yeah, so Ben uh, is one of the old time gods of the ACLU. He's the Are you the deputy director of the national security
No,
or the
we're many jobs past that. Now I'm one of the deputy legal directors of our whole national legal department.
whoa, okay.
So, yeah,
So
but I
you're
oversee free speech, national security, human rights, now immigration, voting as well. So I stopped being a lawyer a long time ago. Now I'm a puller of lawyer strings.
right, and you're the and he's worked in the tech space, he's worked in the national security space, he's represented all kinds of unsavory people, as is his role in life, and we applaud that. He believes in important values like free speech and academic freedom and all kinds of other things,
Access to courts,
access to courts, and
one of our old disagreements. Yeah.
yeah, although not in this context,
No, of course not.
it
In this
never,
context, you do believe in access to courts.
it never would
During
have
the
been.
war on terror, you didn't, but yes. Yeah,
Right.
yeah,
Although
yeah,
I would say well, let's get to old disagreements and how they affect
yeah.
current. Um, and as you can see, he's not above needling me, which is great fun. So without, let's not dwell on the current moment because we agree about everything in the current moment. Um, uh, but I love your idea of going back and saying, is X really related to Y? In other words, is this all my fault? Um,
Yeah.
so make the case, the blame whitus case.
No. Uh, uh, that would be too aggrandizing. I mean, nothing is all your fault. Here's the question. The question is, how did we arrive at a time where even if we manage to make this president weak, he still occupies an unbelievably strong presidency, buttressed by decades of jurisprudence that essentially say courts lay off if the president invokes things like security, national security, and you already saw, for example, in the litigation over the deployment of the California National Guard, an appellate panel jumping to deference. You saw that again yesterday with the Fifth Circuit considering the Alien Enemies Act.
Yep.
Jumping to deference. Since when? Give us one example of when a court has supplanted the president's view of what is wartime. And of course, that sounds very familiar to us. These were the questions when Jose Padilla was snatched at O'Hare Airport and deposited in a brig in Charleston, South Carolina, and subjected to sensory deprivation and beatings, kept away from counsel for years, actually driven insane by this pattern of what I would call torture, finally transferred to civilian courts when it looked like that strategy might collapse. When Jose Padilla tries to bring that case before the federal courts, what is he told by the Fourth Circuit? This is not justiciable. This is the executive's domain. The executive said you were an enemy combatant. That means you don't have access to U.S. courts to pursue your claims. Now, obviously, the same thing happened when people who were kidnapped overseas and flown to CIA torture prisons tried to bring their cases before courts. Essentially, all of these really vital questions at the heart of the relationship between the state and an individual during so-called wartime. I say so-called because you might have thought that was wartime. I doubt you think that we're in a real war versus
Right.
Antigua. Were non-justiciable. It's not that the courts disagreed with our legal theories. Perhaps they did. It's that on a range of issues, from whether, again, a U.S. citizen picked up on in the United States and subjected to torture, whether that was legal, whether that comported with the Constitution, what the limits might be on the president's use of lethal force against U.S. citizens, whether the intelligence community could engage in warrantless surveillance of United States citizens outside of statutory rules that were set up for that situation. In case after case, the courts deem these questions non-justiciable. They don't grapple with the legality of this, and instead they sort of extend a series of precedents that started in the Cold War, a time of genuine existential threat, when you're talking about, a nuclear-armed superpower, and apply these to the context of transnational terrorism, which is always a threat, and probably not, maybe we would agree, an existential threat. It's ineradicable, but not existential. And so I will tell you that when the Supreme Court gave Donald Trump a pass, a criminal pass, on what he could do in office in the immunity decision, to me, it was less a shocking new development than a continuation, really
Mm-hmm.
more of the same. Since when have we held U.S. presidents accountable for the things they did in office? If Dick Cheney and George Bush could set up an archipelago of secret prisons and subject prisoners there to tactics that were developed by actual Nazis, in what sense could we say that for the first time the presidency was above the law? Now, I know we disagree because at the time, your characterization of lawsuits aimed at bringing some legal boundaries to those kinds of practices was that this was criminalizing politics, nothing more or less. Your words on the Lawfare site. If that was criminalizing politics, you know, now the lawsuits against Trump are much more closely related to what I would call politics. What the president can do vis-a-vis the other branches, than the question of whether human rights treaties and principles that the U.S. had long subscribed to should be enforceable in a court against those presidents. So I guess what I would say is, go back and read Justice Jackson's dissent in Korematsu, where he says, with this decision, we are loading a weapon. And the weapon that we're loading right now is going to be used by someone who has sort of none of the constraints of the current situation. My view of
I just
those,
want to point out, though, that Justice Jackson um, uh, argued in that dissent that the case was non-justiciable.
no one's perfect. So, but I would argue that
It's not the part of the
that's
opinion
correct.
that people remember.
Dictum. No, it wasn't. No. That we loaded the proverbial gun with these non-justiciability rulings, and basically the dominant doctrine of national security law is deference to the expertise of the executive branch. All of this, and I think essentially what's going on in all these cases is judges actually do trust the presidents who are in office. Whereas what judges are supposed to be doing is thinking about what president is not yet in office, what rule is going to govern the next one. At that time, you were buddies with the people who were making these decisions, some of them good, many of them, I think, catastrophic. You did trust them, more or less. You trusted them more than a bunch of scrofulous human rights lawyers who were sniping at them from the sidelines. Um, but if you map those rulings onto the current situation, there's a whole legal architecture that is going to make it much, much more difficult for us to constrain a presidency, unless and until, and we've seen a little bit of this already, the Supreme Court in particular is willing to acknowledge that what we're dealing with right now isn't normal. And that all the ordinary presumptions that should be afforded to a co-equal branch don't apply when people like Emile Beauvais are being empowered, to basically destroy the integrity of these institutions and enforce the leader's diktats. So, listen, I'm drawing a squiggly line, not a straight line, but I am saying that there were those of us 15 years ago who were talking about the slippery slope, and we kept on feeling like we arrived at the bottom of it, and it kept on going down, and here we are.
Yeah. So let me offer a modest defense. And let me start it by saying that there is no small justice in the accusation that you make. Um, Anytime you are dealing with a slippery slope argument and you find yourself at the bottom of a slope, it is worth asking the question, is that the slope you slid down? And I am not going to say that the arguments that those of us who believe in a strong executive in principle for purposes of national security protection are should be confident that we did not contribute to arguments that are now being made and exploited. I will say, I have no, I have no, uh, um, I have no particular defensiveness about thinking about the role that those of us who made, I think, good faith arguments for a stronger executive than people like you made good faith arguments against, are, have some, uh, we all have things that we've written that don't look so good. And we should all ask ourselves, what role did we play in getting here? And I'm not shy about that at all. I will say a few things. First of all, the deference was much older than the war on terror. And it's
Right.
interesting.
I mentioned it has its roots in the Cold War, but it's
Right,
not much older than that.
it has its roots actually beyond the Cold War, but that's a separate
I mean, the concept
conversation.
of national security doesn't exist before the Cold War. So,
Right. Although, there's a lot of deference given to Woodrow Wilson on a lot of things, um, including locking all kinds of people up for what we would now consider core First
fair.
Amendment protected speech. Um, I look, I think that it is interesting to me that the core question that was before the Fifth Circuit yesterday was all about Ludicky v. Watkins, not about a counterterrorism precedent. Now, is that a Cold War precedent, or is that I mean, it
Well,
takes
that's
place.
but of course the reason for that is that the Alien Enemies Act was not invoked in the context of the war on terror,
Yes.
right?
Well, I would like to think that had the Alien Enemies Act been invoked by the Bush administration, I would have been as outraged then as I am now.
But
Uh,
let's break that down because, in what sense is the broadest reading of the AUMF, for example, the broadest reading of it, that different from invoking the Alien Enemies Act against people in the United States who are associated with Al Qaeda?
well, first of all, I have never believed in the broadest reading of the AUMF, and I did say, back then there are things this instrument does not do. Um, and by the way, the very first editorial written against the way the administration was handling Jose Padilla was written by me. Um, and so, I, the first point I would like to make is that I am not quite the caricature of a John Yoo that you make me out to be, and wasn't at the time. Um, the second point I would like to make is that um, uh, the role of good faith here is important, and I I want to say a few words in defense of George W. Bush and Dick Cheney, who did some terrible things, embroiled us in a war that was exceedingly ill-advised on the basis of information that turned out to be false, and certainly authorized the treatment of people in fashions that nobody should defend. Um, I don't doubt that both of those men took their oaths of office seriously and did what they believed was in the best interests of the nation, and also did what they believed, acted in ways that were constrained by law, albeit law interpreted by David Addington and other rogues, but b were were that they were operating in a framework in which their genuine attitude was one of patriotism. And I do think, and this gets to your point, unless the Supreme Court comes to understand that things are different when that's not true, that there is this underlying question that I never considered until Donald Trump's first election. And then I wrote a long series of meditations about it, which is, what if you don't believe the president's oath is sincere? And I do think that that changes everything. And once you accept that premise, it does cause a revisitation of a lot of what I thought 15 years ago, but not quite in the way that you're describing. Um,
I
and
understand that. I mean, I think that there's something in the nature of being, particularly an ACLU lawyer, that forces the exercise on a daily basis of thinking abstractly. Because we're not a progressive organization or a left wing organization. We're a Bill of Rights organization. Our most famous cases involve liberal lawyers eating bowls of shit to
to
represent
represent Nazis,
Nazis in Skokie or
Skokie,
people in Charlottesville or so, right, or last term to represent the National Rifle Association before
right?
the Supreme Court in a First Amendment case. That's really what we're known for more than anything else. So every time we're taking a position, we're playing out all the dimensions of it. What if? What if? What if this kind of person had that power? And not just when we're taking cases, but when I'm trying to explain to people why we have to represent the National Rifle Association. I say, this is the playbook for Ken Paxton in Texas to destroy Planned Parenthood. And if Andrew Cuomo can do this to the NRA in New York, nothing will slow down Ken Paxton in Texas, right? So we're always thinking, not is this a decent man running the country, but what will an indecent man do with this particular authority? Because we don't assume that you get to rewrite the rules for that situation. And it turns out that we may not be rewriting the rules for that situation, and that the Supreme Court has this incredibly strong impulse to not do that, to think about the office and rather than the person. And and this is why I say again, not you and your cohort created the situation, but I think you and your cohort were excessively focused on what you perceive to be the decency of the people who were making these decisions, the hard choices that you had to make. And this is why you thought that efforts to bring legal accountability for the excesses of that were improper. Because they were in a difficult situation, facing difficult choices, and there was something perverse about then bringing that in front of a court to say, did they get it right or did they get it wrong? The important thing is they were decent and they were faced with hard choices, and that didn't need to be litigated. And that's where I think we disagree, because I think there would have been tremendous value to applying the law in those circumstances. It wasn't about throwing anybody into prison. It was about actually saying, getting a definitive legal adjudication. I always said the real problem with non-justiciability here is not that my clients didn't get their day in court, but that the system never got an answer to these questions. Right? We
Now,
never got a definitive legal adjudication of some of the most important questions that should be at the heart of something that we call national security law.
so let me turn the accusatory spotlight back your way.
Nice.
Not at you in particular, but as you would say about you and your cohort.
Yes.
It seems to me one of the striking things you focused on justiciability and deference, which is an area where you definitely hit on, had some important insight. Um, but there's some really important areas where the civil liberties community and the human rights community just completely missed the boat. And I want to focus on a couple of them. During the Obama administration, you guys were very focused on things like the propriety of drone strikes, the NSA's surveillance programs and the justiciability of that, the the I guess the detention litigations were a bit earlier. Actually, they were sort of
They
Bush.
continued. Are you
They
talking about?
continued, but they
Yes.
weren't. I won't say they were your great focus in
They
2013,
they were top of
14.
mind for the lawyers who were representing the men in Guantanamo, but they were not top of mind in the community as much. And actually, we should stop there for a second because even the sort of three great triumphs of the rule of law, the Rasul case, which opened up Guantanamo, the Hamdan case, the Boumediene case, right, which said the great writ of habeas corpus cannot be removed by Congress in the context of Guantanamo. The court never said, still has not said, who can be held at Guantanamo, for
Right.
how long, or why. These were all decisions about the power of the courts, not about the rights of the people there.
And
And
to
and
be fair, you and I always agreed about that.
yeah, and I mean,
Um,
but I think that this is what I'm most worried about being the roadmap for the Supreme Court under Trump is that they actually will defend judicial
their
power.
own,
They just
right,
won't exercise it.
right. Um,
And that's what happened in the Guantanamo litigation.
So I actually, Bobby Chesney and I wrote a whole treatise about the law of detention as emerging in the lower courts,
Right.
none of which was it was the result of kind of the most vaporous noises from. But I want to point out that there were big things you guys missed, and one of them was so when I first wrote my in 2016 my kind of analysis of the relationship between the personality of Donald Trump and the presidency. I had to spend, and this is the first time anybody had ever kind of done that in at least in a legal context. I had to spend the first third quarter of the piece explaining why civil libertarians were getting the anxiety about why this is scary all wrong. Because the people who, it's not you individually, but the people
You
who
can
were
take it.
no, it wasn't you. It was Connor Friedersdorf and Jennifer Granholm, and they were writing these breathless pieces about Trump proofing the presidency that were all about preventing domestic drone strikes and
Oh,
preventing the and reining in the NSA's programs because it would obviously be applied domestically. And I wrote a piece that said, hey, you guys are missing the point. The point is the Justice Department and the routine regulatory authorities of the United States. And that once you take the, like, basically warned about Emil Bovy. Um, and the the question is, are you guys too focused on justiciability and things that are kind of these esoteric things that get applied once, twice, 100 times, rather than on the powers by which actual authoritarians exercise power.
I mean, in defense of some of the community, Karen Greenberg wrote a book about the Justice Department at around that time and about what happened to the Justice Department, and Alberto Gonzalez and others, and the remember the hospital room encounter, right? There certainly was focus on the Justice Department, but look, I mean, in a sense, you respond to the issues that are actually taking place, and you make an attempt to understand how those issues will apply later on. And it sounds like the mistake that Friedersdorf and others made was thinking, that our fear was that there was going to be a drone strike in Minneapolis. I don't think you ever heard anybody in the human rights community making an argument like that. That wasn't the concern. The question was, will courts, as they do in many other democracies, have any role in setting and policing the guidelines? And now even countries that permit targeted killings, like Israel, for example, have a whole series of Supreme Court cases in which they grapple with the military's arguments and the intelligence community's arguments about what should be off limits, and come up with more or less a set of protocols. And the courts have an involvement. Essentially, what we were saying was, why are we so different from the Israeli Supreme Court? You bring a case to the Israeli Supreme Court and you say, the wall that you are building across occupied territories is, destroying these olive groves. And the military says, this is a question for the military. This is not a question for courts. This is about defense. And the Supreme Court in Israel says to the military, you're the experts in defense. We're the experts in proportionality. We're going to weigh the claims that are being brought by Palestinians, by human rights advocates. We're going to take your claims very seriously, and we're going to say, actually, no, your plan draws the wall in the wrong place.
And we have original jurisdiction
Well, okay,
over the
fine.
question.
Yes, maybe. But I mean, to me, that's the lesser question is, there's
Is
no,
somebody
you
doing
couldn't
that?
say in Israel that the security concerns are somehow less than what the security concerns in the US were vis-a-vis Al-Qaeda or ISIS. No, I mean, you're actually talking about where a wall is going to be drawn to divide populations in what has been a more or less an active conflict for decades. And that court unapologetically says, we're part of this process. We know, you say we're not experts in security. It's not our job to be experts in security. It's our job to be experts in proportionality. It's our job to be able to weigh all the issues in society. And our argument here was that when you invoked security here, or secrecy, in our doctrine, that has become absolute. And so when you invoke the state secrets privilege, and I don't know if you saw it, it was a little noticed case from a few years ago where Abu Zubaydah's case was back in the Supreme Court in relation to an investigation in Poland.
Yep, I remember.
Yeah, and so the question is it more or less, the question is it a state secret that the CIA had a prison in Poland? A question that is a joke to most of the world because the former president of Poland has given long interviews about it. He authorized it. He was there. It's not in any meaningful sense a secret. Now, I understand the intelligence community's point that there's a difference between something that everybody knows and something that's officially confirmed, that it can create more diplomatic awkwardness to officially confirm something. But 7 justices of the Supreme Court say that's enough. We don't need any more. You've told us that it would be awkward, so we're going to essentially affirm, written by Justice Breyer, we're going to affirm the idea that this is still a state secret. The leading the dissent is written by Justice Gorsuch. He says, there comes a time where we have to stop ignoring as judges what we know to be true as human beings, as citizens. And enough is enough here. 20 years have gone by. Towers are not going to fall down if we allow this investigation to go on, acknowledging what the whole world knows. Justiciability is not a fringe issue. Justiciability is the question of whether the courts have a role in enforcing the law. To me, it's the core issue. It's not unrelated to your concerns about the operation of the Justice Department. But at the end of the day, what did Justice Roberts say? The framers didn't fight a revolution for internal agency protocols. They fought it for separation of powers.
Okay, but hang on a
Yeah.
second. If you take the view, let's take the full Aharon Barak everything is justiciable view for purposes of argument. Um, and I don't take you to, I don't want to caricature your views.
I
So,
I probably do take that view, but
okay.
yeah,
So
yeah, yeah,
you can go there if you want.
yeah.
But I'm not going to go there for you.
Okay,
Let's take that full view
yeah.
that everything the government does should be subject to judicial review within a reasonable period of time. But now you
By the way,
put,
I'm not saying that there's a difference between everything the government does should be reviewed
no,
to
and
everything the
should be
government does should be
reviewable.
reviewable. Yeah,
Yes.
basically.
Um,
Yeah,
I,
yeah,
but if you take that view
yeah,
and then you put in charge of the government somebody who will, um, and I want to say, like, this tears me up because I read Amy Coney Barrett's opinion the other day, and I think there's a lot of merit to it as a matter of pure law. And then I listened to the Solicitor General say to the Supreme Court, we don't commit to following circuit precedent, even within a circuit. And by the way, we'll appeal it to you if we feel like it. And, what they're basically saying is, yeah, the principle here is fuck you. And, and so I don't really understand in an environment in which you have no commitment to actually follow precedents and to apply precedents to similar situations elsewhere. You have no commitment to following a court order at all. See a half dozen immigration cases. They do have a way of dragging them into compliance over time, but there are still some, there are still 200 people in El Salvador on the basis of flights that should have been turned around under a court order. I'm trying to figure out, in the absence of the sort of civic virtue that gets you to non-gamesmanship and
yeah.
compliance, why why is the most important issue
Let's not
justiciability?
talk about what's the most important issue. Let's talk about an issue that is indispensable. There's nothing without it. There's not right. So without justiciability, then you've basically moved the judicial branch off the board, and that's not an option. So my question as a litigator, and I get asked this all the time, it's like, is it the break glass moment yet? Remember, it's 5 fucking months into this administration, right? We've just started. So is this the time? And my view is, we only get so many times of saying this is the break glass moment. Everyone into the streets, and so I ask, is litigation working?
Oh, there's
You know,
no question that
you're
the litigation
yeah.
is
So
working.
so I mean, I think you can count on one or two hands.
But
I mean, there are many cases where their lack of civic virtue, their lack of basic decency and ethics, has created enormous harm. But in the minor end of cases where we're getting injunctions, the injunctions are being followed. And so I still think a you know this Supreme Court is a universe better than no Supreme Court when it
yeah,
comes to these issues,
yeah.
right?
So I want to foot stomp this
Yeah.
point and articulate it in a way that I want to see
Okay.
if you agree with. People ask, is litigation working as a binary?
Right.
And that's the wrong question. Think of all of these authoritarianism questions as existing on a rheostat.
Yeah.
You got your Hitlers and Stalins or tens. You've
Yeah.
got your functioning Finlandish liberal democracy as a zero or
Yeah.
a one.
Yeah.
Um, and um, and the question is litigation moving the friction, causing that rheostat to be a bit lower than it would have otherwise been, along with a bunch of other things, including, by the way, that the much maligned Congress of the United States, which deserves every bit of maligning that it's getting, is still adding friction to the passage of this crazy
Yeah.
domestic policy
Another way of
legislation.
putting it is, so far, the administration has governed 100% through executive orders and 0% through congressional authorization. And
Right.
that in itself makes this presidency weaker by many measures than it would be if the congressional party were supporting and endorsing and ratifying this whole agenda all along. I share that view. I would say I don't think that litigation is moving the dial a little. And I think the way to understand that is, erase all the cases brought by Public Citizen, by Democracy Forward, by the ACLU, by all these groups. Just imagine that none of them existed. And now think about how different today is 5 months into the administration than it actually is. It's not a little different. It's massively different,
That's right.
right? Massively
Um,
different. It's the only, so far, really effective check on what's going on. And again, the last thing I want to do is valorize the role of lawyers. And I've said this, to others. You heard me say this to Virginia. What we're doing is throwing sand in the gears. We don't have a lot more ability than that. But that's our job, is to throw that sand in.
buying
By
time
time.
for the political
That's
process
it.
to respond. And by the way, it
That's
does
it.
not guarantee that the political process
Correct.
does respond.
It doesn't. That's right. I mean, if a political majority, a popular vote majority, chose this. Maybe they didn't know exactly what they were choosing, but chose this after witnessing the last Trump administration and then his conduct on January 6th and then the cases that followed. I can't say that a political majority won't choose this again in 2026. I don't think it will. I suspect we're going to see something dramatically different in 2026. And, my great hope is that Trump has a kind of special sauce, and that this movement can't be passed on to someone who doesn't have his unique skills. But then, of course, I look at what's going on in other countries that look like ours, other Western democracies, and something like it is happening in most of those countries. There is some kind of right populist movement focused around immigration and cultural values that is attracting working classes who you would expect traditionally to identify with left-leaning parties because of their economic interests. And so that's not unique to this country. And again, my hope is that we have a lot of advantages here, that when you move Trump off the board, we'll be able to return to something that allows us to be on two sides of the issue and not on the same side. Right? That's the health of a democracy, when you and I get to be frenemies again, and not blood allies, trying to save the nation.
Yeah, so that's an interesting question. Imagine a hypothetically sane post-Trump environment. Are we frenemies again, or have we learned enough from the sensibilities that one another brought to the
Yeah.
table that it turns out we discovered underlying shared values that we might disagree about certain things, but whatever.
Yeah, I don't know. It depends what the issues are. It depends who the leader is. We'll see. We will see. I think we ACLU, right? Will be, in this area, more or less advocating for the same principles and concepts. Um, uh, you know, will if a second Obama appears in 2028 and says we need to look forward, not backward, what will be your reaction to that after 4 more years
Yeah,
of
that's an
Trump?
interesting question. So, number one, I am vindictive about this, and
But
I
you probably liked Let's Look Forward, Not Backward in 2009.
I did, but that had
Yeah,
everything to do with my view of good faith,
yeah,
and good faith, and a sense that people made very hard choices under circumstances, as you said, somewhat mockingly, that I regarded as not necessarily, very much not in some cases, the choices I would have made, but I didn't want to judge. And right now, I feel completely differently. And maybe you could even goad me into saying I was wrong that time, but I haven't thought through that. because I'm looking forward, not backwards. And what I am thinking is we need, we really need a powerful set of disincentives to be the person who puts on a mask and tackles somebody on the street. We need a powerful set of disincentives, really powerful, to be the person who authorizes that.
And that's exactly how I felt about the person in the torture chamber who put on the mask and who took off the gloves and started drowning people, and the person who authorized that. And instead, we said, the person who was doing it was following orders. The person who ordered it was justified by a lawyer, and the lawyer was only a lawyer. So there was nobody in that triangle who was actually responsible for that. So look, I actually agree with you. It is about what are the incentives. Take morality even out of it. But how do you change the incentives? Like, let's talk about for a second, the attack on law firms. It's a big jump from where we are. But do you think that we, in the last few months, have managed to change the incentives that someone like Brad Karp is dealing with when he has to decide, am I going to go to Washington and eat the meatloaf, or am I going to go to court and fight this order? Because that's really what we need to do. I mean, one of my frustrations in the first Trump administration.
Right, but hang on
Yeah,
a
yeah,
second, because I think that's a really good
yeah,
example. You're, you operate in a world of lawyers,
yeah,
and it is fair to say what is the incentive structure facing the managing partner of a big
yep,
firm. But I want to say, what is the incentive structure facing the guy who does the shakedown, and we all know his name, on behalf of the president in a quasi private capacity, who goes to law firms and says, hey, X law firm paid
yeah,
$170 million in. You need to do twice that if you're going to avoid
yeah,
an executive order.
yeah,
That person, people who were doing, well, let me
yeah,
be careful about how I say this.
yeah.
People who were engaged in shakedown extortion schemes need to be prosecuted.
I agree, and so that's where we agree. I mean, I was going to make a sort of side point, which is to bring it back to us and to everyone, because I do think that everyone listening here, everyone everyone is going to encounter, some discomfort in this Trump administration that they didn't in the first. To me, one of the frustrations of the first Trump administration in my social political class was, you know, everyone had a total neurotic breakdown, but actually materially, if you were a progressive liberal, um, the first Trump administration didn't touch you. Your taxes were lowered. That was basically it. You got a little richer. You had to be stressed out watching MSNBC every night and hearing about what the Russians were doing. But
I just
materially,
want to say I was in a different position from that.
okay, yes, I understand. But yes, because you were one of a small handful of people who might have actually been facing legal jeopardy. But that was
And
a
because I was constantly
yes,
advising people and trying to employ
yes.
people and trying to protect people who were facing immediate
In
consequences.
every way, you are not my typical progressive liberal. You're not typical, and you're not a progressive liberal. Um, in this administration, the attack on the law firms is sort of this moment where Trumpism actually comes home and hits people who are very, very close to us. This isn't someone being scooped off the street, by mass people because it doesn't, because they wrote an op-ed. This is actually the partners at major law firms who do pro bono cases, who are the real power structure, the real establishment. And that's something new. And the question is, who are they in that moment? And the first answer is unbelievably dispiriting. They are people who, when sort of faced with history coming to their doorstep, decide that keeping their partners who have second homes and boats is more important than standing up for the country, for the values of their profession. And I say to these people, if all you wanted was money, why did you go to law school? Your clients make more money than you do. You obviously believe in the values of the profession in some way. And so what we've really tried to do over the last few months, both through the litigation supporting the law firms and through massive public censure of these decisions, is when you have that Lord Jim moment, when you're standing on the boat and you're not sure if it's sinking or not, right? Lord Jim jumps off and it's not sinking, and that defines his whole life. You might have this defining moment. You are going to be judged by how you respond right now. You shouldn't be keeping your chips over here to maybe play them later. I really think in a way the law firm's decision to capitulate and Harvard's decision to fight are two of the really defining moments of the first 5 months of the Trump administration in terms of setting elite incentives, realigning elite incentives about, what the risk and reward is of different strategies. I hope I'm right about that.
I think you are. I also, we have 4 minutes left, and I do want to say a word of unabashed, uncomplicated praise. So, first of all, a few months ago, about a year ago actually, I had a run-in with the DC police over whether they could stop me and the Ukrainian ambassador, which they did, from planting sunflowers in front of the Russian embassy. And somehow the Russians had gotten to them and gotten this idea in their heads that we were going to disrupt a gas line, and so they stopped us. And your colleague Scott Michelman took on me as a client, and did just a remark. It never got litigated. It was never, but just a really good job interfacing with the DC police, and making clear that we were absolutely within our rights. And this year, it got corrected last year, and this year the sunflower planting went off without a hitch. This is some of the quiet work that ACLU lawyers do, outside of the Trump
Yeah.
context, just
Yeah.
basically protecting people's First Amendment rights.
I want to
And
take just a small victory lap here because
wait, wait,
I,
wait, wait,
I
wait, wait,
hired
wait.
Scott Michelman when he was a first year law student at Harvard as an intern, and now he's one of the finest lawyers in the country.
Yeah,
Back
so
to
I
you.
just want to say, I have been really so Scott is, I guess, second chair on to Legal Learned on these giant immigration cases, Alien Enemies Act cases, and compliance with court order cases. And I have this joke with my lawfare colleagues that, yeah, in his side practice, he protects me from the DC police. This is, but going from that little thing, making sure that a group of Ukrainians and one eccentric, middle-aged desk worker can plant sunflowers on a particular patch of land, to making sure that when the government deports Abrego Garcia illegally, that there's some mechanism to get him back. That kind of vacillation between the big things
Yeah.
and the very little things that still matter, is something that your team is just remarkable about. And I gotta say, as somebody who has personally benefited from it, and also tangled with you
Yeah.
guys in the exercise of it, and also felt very represented,
Yeah.
not in a formal sense, but wrote lawfare piece after lawfare piece in praise of the arguments that you guys have
Yeah.
made in some of these cases. I cannot express how much I value the function.
All I can say is I appreciate that very much.
One last story about Ben Wizner before we wrap. in the height of our days as frenemies, we found ourselves on a panel together at the Harvard Law School, and really went at it. And afterwards, we're having dinner with a group of Harvard law students who had invited us. And I don't know why I was feeling obnoxious, gave them a lecture about having fun professionally and valuing the work that they did and being willing to not make money in order to do it. And Ben broke in the middle of what I was saying and said, look, he and I disagree about just about everything, but right now he is channeling the word of God into your heads. And I like to think, I have no idea if anybody there listened to a word of it, but I like to think that that moment presaged the convergence of a lot of what has happened since.
I think so. Look, you and I both know that we have one life, and the most trivial thing that you can do with it is to try to just accumulate worldly possessions. And the important thing to do with it is to the best of your ability, try to shape the world, in your small or big way. So, Ben, I hope we'll do this again. I hear you do it every day.
I do it every day, and the rule is once you've been on the show, you have that link, and you are invited to just show up uninvited anytime. Our former guests do. I never know who the co-hosts are going to be. I sometimes have a guest, sometimes don't. And
I
you're
could
welcome.
really just pop in.
You can really just pop in.
Right.
And it is sometimes people pop in often enough that they become co hosts. And look, you're a great American. You are welcome back anytime. And it is a pleasure to see your face, even
Respect.
if you pronounce the I in your name wrong.
Much respect. Take
Cheers.
care.